5 seconds to go. Start. The exclusion jurisdiction clauses in all other legislations enacted under the aegis of Articles 323A and 323B, to the extent they exclude the jurisdiction of the High Courts under Articles 226 and 227 and the Supreme Court under Article 32, of the Constitution, was held unconstitutional besides holding clause 2D of Article 323A and clause 3D of Article 323B, to the same extent, as unconstitutional. Stop para. Further, it was held thus, the jurisdiction conferred upon the High Courts under Articles 226 and 227 and upon the Supreme Court under Article 32 of the Constitution is a part of the inviolable basic structure of our Constitution. Stop. While this jurisdiction cannot be ousted, other courts and tribunals may perform a supplemental role in discharging the powers conferred by Articles 226 and 227 and 32 of the Constitution. Stop. The tribunals created under Article 323A and Article 323B of the Constitution are possessed of the competence to test the constitutional validity of statutory provisions and rules. Stop. All decisions of these tribunals will, however, be subject to scrutiny before a division bench of the High Court within whose jurisdiction the tribunal concerned falls. Stop. Para. When once a constitution bench of this court declared the law that all decisions of tribunals created under Article 323A and Article 323B of the Constitution will be subject to the scrutiny before a division bench of the High Court within whose jurisdiction the tribunal concerned falls, it is impermissible to make any further construction on the said issue. Stop. The expression all decisions of these tribunals used by the Constitution bench will cover and take within its sweep orders passed on applications or otherwise in the matter of transfer of original applications from one bench of the tribunal to another bench of the tribunal in exercise of the power under section 25 of the Act. Stop. Para. In other words, any decision of such a tribunal, including the one passed under section 25 of the Act, could be subjected to scrutiny only before a division bench of a High Court within whose jurisdiction the tribunal concerned falls. Stop. This unambiguous exposition of law has to be followed scrupulously while deciding the jurisdictional High Court for the purpose of bringing in challenge against an order of transfer of an original application from one bench of tribunal to another bench in the invocation of section 25 of the Act. Stop. Para. The law thus declared by the Constitution bench cannot be revisited by a bench of lesser quorum or for that matter by the High Courts by looking into the bundle of facts to ascertain whether they would confer territorial jurisdiction to the High Court within the ambit of Article 226(2) of the Constitution. Stop. We are of the considered view that taking another view would undoubtedly result in indefiniteness and multiplicity in the matter of jurisdiction in situations when a decision passed under section 25 of the Act is to be called in question, especially in cases involving multiple parties residing within the jurisdiction of different high courts, albeit aggrieved by one common order passed by the chairman at the principal bench at New Delhi. Stop.